Before the United States Supreme Court, the United States Department of Justice has just advanced, in my view, one of the most absurd, goofy arguments that I've ever seen in the United States Supreme Court, literally attempting to justify their expansion on behalf of the ATF of the definition of firearm in the Vanderstock case dealing with frames and receivers, or so-called political propaganda term, ghost guns. You're not going to believe this argument made by the Department of Justice and the ATF before the Supreme Court. It's crazy, and when I break it down for you, I think you too will be shocked. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. We must always learn from the mistakes of others so we don't lose our fundamental rights, including our right to keep and bear arms. All right, folks, so you're quite familiar already that on October 8th of this year, before the United States Supreme Court, there will be an oral argument in a major Second Amendment-related case dealing with ATF authority. Don't forget, power and authority are not the same. The ATF's legal authority, allegedly so, to regulate so-called ghost guns, which is a political propaganda term invented by the left to describe unserialized firearms, i.e. firearms that don't have serial numbers. Now, what happened here is that the Joe Biden administration with Kamala Harris, who's the gun czar, the gun control czar, in addition to being the border czar, they went out there and knew they could not enact massive gun control legislation regulating so-called ghost guns, again, which is simply unserialized firearms. So the ATF, at the behest of the Biden-Harris administration, took it upon themselves to expand the definition of firearms to include not just firearms, to include not just frames or receivers of firearms, but also really parts that ultimately, looking futuristically into the future, could conceivably become gun parts that become part of or become a frame or receiver if there's additional milling, manipulation, parts added, whatnot. So again, what the ATF did here is they expanded through regulation the definition of firearm so they could force more people to have to undergo a background check through the NICS system because there would be more guns as defined by the ATF, and there would be more companies that would have to go out and get FFL licenses in order to sell these gun parts. This is all designed, of course, to destroy an area of the firearm industry in the United States. Now, what's been going on is the Supreme Court granted cert in this case in the spring, and the briefing has been going back and forth. The final brief was just filed by the United States Department of Justice, and now the next step in this case is oral argument on October 8th. Now, the Department of Justice has literally just made one of the dumbest arguments I've seen made in the Supreme Court. Let me read it to you, and then let me explain why it's simply absurd. I think you'll be able to tell immediately the absurdity of the statement in the U.S. Supreme Court made by none other than Merrick Garland's Department of Justice on behalf of the ATF, Kamala Harris, and Joe Biden. Here is what they write in their reply brief in the Vanderstock case, which of course is a challenge to whether or not ATF has authority to expand the definition of firearm to include not only frames and receivers, but parts of frames and receivers, or things that could potentially become parts of frames and receivers. Here's what the DOJ writes in their brief. Guns sold without serial numbers, records, or background checks are uniquely attractive to people who are prohibited from possessing firearms or who plan to use them illegally. And communities around the nation saw an explosion, listen carefully folks, saw an explosion in crimes committed with an untraceable ghost guns. The rule that they just promulgated, the one being challenged, the rule responded to that public safety crisis by reiterating and clarifying ATF's longstanding view that the plain text of the Gun Control Act does not permit such ready evasion. The parts kits covered by the rule fall squarely within the Act's definition of a firearm because they may readily be converted to expel a projectile by the action of an explosive. So let's just think about what the DOJ just said. They said, we, in our intellectual wisdom, with our infinite wisdom as intellectual giants in the Second Amendment community in the gun space, we ATF and DOJ under Joe Biden and Kamala Harris have identified a brand new super duper duper dangerous problem in America. The explosion of so-called ghost guns. Scary. And in response, and here's what's so absurd about their argument, ready? And in response to this brand new super duper dangerous problem of ghost guns, privately made firearms, what did they just say they did? They said, we did what we've always done. That's it. We have a new problem, and what is our response at the ATF is more of the same. We simply reiterated what we've always been doing. What? You've just identified an alleged new problem, and you just told the Supreme Court that in response to this new problem, you simply did what you've always been doing. No change. You literally write in this brief that the rule responded to that public safety crisis, the new one, right, by reiterating and clarifying ATF's long-standing view. What? Which is it, folks? Is the DOJ saying that in response to this new alleged problem of ghost guns, that they've done nothing different, the same? Well, either that is entirely inconsistent with how you address a new problem, which is with new solutions, presumably, or they're simply lying to you. They're BSing you. Which is it? Well, I'll let you be the judge of that. I'll put a link to the brief down below, and you can read. You can tell me what you think. But I think that's simply absurd to say there's a new explosion of a problem, and in response to that, we basically have adopted this new regulation, which does nothing more than reiterate our long-standing view involving the Gun Control Act, which basically means they're trying to tell the Supreme Court that in response to this new thing, we've done nothing new, nothing different. Now, why do they say that? We know why they said that. Because they're about to get spanked by the Supreme Court, because what they did is clearly illegal and unconstitutional. That the Department of Justice and the ATF decided to take it upon themselves as a king to simply issue an executive order fiat to expand the definition of firearm beyond the scope of what the Congress defined it as in the Gun Control Act of 1968. But let's dig deeper. There's even more absurdity in this argument by the Department of Justice on behalf of the ATF. In addition to the fact that clearly that argument they just advanced is internally inconsistent and absurd, and the Supreme Court will clearly get that immediately when they read this. It will definitely be a head scratcher on the Supreme Court among the justices. You wait and see what happens at oral argument. But let's go back and let's see some of the other points they made. Now, here's the weird part. Now, they just said that they've reiterated and clarified ATF's long-standing view. Oh, really? Well, what's fascinating is when you compare that statement with the administrative record submissions made by the ATF and the Department of Justice itself. Guess what they say on page 44? I'll give you the page numbers. On page 44 of the administrative record, the official regulation and the description of it. On page 44, they literally predict that 42, listen carefully, 42 out of the 43 non-FFL kit makers are going to go out of business. Hear what I just said? The ATF DOJ itself is literally saying that even though all we did is reiterated what we've always said, our long-standing policy that parts that can give rise to a frame or receiver are firearms, they then go on to say that, yes, we admit 42 out of the 43 non-FFL businesses will go out of business. Well, how is that possible that if you're simply doing what you've always been doing and yet somehow, miraculously, 42 out of the 43 non-FFL kit makers go out of business? Obviously, it's BS because what's happening here is the ATF literally changed the definition of firearm to go beyond the scope of Congress's definition of firearm. It has nothing to do with a reiteration of long-standing ATF policy. Right? Total BS. But let's go beyond that. Let us dig deeper. Now, they literally write in this brief, they're talking about a public safety crisis. Come on. Who do you think is on the other side, Department of Justice? Do you think we're a bunch of rubes? Knuckle-dragging rubes that can't do math? Come on. You got to do better than this, DOJ. I know you got some fancy credentials, but I can assure you Second Amendment community's got some fancy credentials too. Okay? So let's just talk about some of the data that perhaps you thought would slide by us. Slide by the Second Amendment community. Slide by the viewers of this channel on the Four Boxes Diner. Not going to happen. Let me give you a couple examples. If you look at the administrative record submitted by none other than the Department of Justice itself to justify their rule on behalf of this alleged to address this so-called public safety crisis involving PMFs or privately made firearms or ghost guns or unserialized firearms. Guess what they say? They literally say, let's talk about the crisis. They talk about the years 2016 through 2021, 2016 through 2021. During that time, they say they have found out that 4,288 felons possessed privately made firearms. Hear what I just said? 4,288. All right? Let's put that into some context, because we're not stupid. We connect dots. Yes, we do. They then go on. Now, that's what they say on page 48. Well, let's compare what they say on page 61. Well, on page 61 of the administrative record submitted by the intellectual giants at the ATF and the Department of Justice, they point out that by their numbers, there are over, ready, 1 million owners. Hear what I just said? 1 million Americans own 2 million privately made firearms. 1 million people. Let's do a little bit of math, shall we? Let's take 4,288 felons and divide that by 1 million owners of privately made firearms. When you divide 4,288 by a million, you get literally less than 1/2 of 1%. 1/2 of 1%. Not even. Of the number of people that own these privately made firearms in the United States are felons. That is an absurdly low number. Okay? But let's go beyond that. This so-called, remember, I'm not the one labeling this a public safety crisis or an explosion in crimes committed by untraceable ghost guns. Not my language. This is the DOJ language. This is ATF. So what else did they say? Let's talk about this explosion and crisis. Well, the next thing they talk about, and again, this is their data. This is ATF and DOJ's data. This is what they submitted. Not Mark Smith. Not the Four Boxes Diner. This is what they submitted. They then go on to say on page 48 of their submission, there are 692 homicides or attempted homicides in the 6-year period of 2016 through 2021. 6-year period. 2016 through 2021, 692 homicides or attempted homicides. Not even homicides. Homicides and attempted homicides. A total number of 692 allegedly committed with untraceable ghost guns, privately made firearms, whatever you want to call these ghost guns, which is what they're calling, the anti-gunners are calling them, okay? Now let's put this into perspective. A quick Google search shows that somewhere in the order of magnitude of, let's say for the sake of argument, there's 20,000 gun-related homicides in the United States every year, okay? Over a 6-year period, that number equals, well, you know the number. It's 120,000. Obviously, it's too many. Most of this is gang-related. You want to talk about solving gangs, we can talk about that in another video, but that's not what we're talking about here. So you got 120,000 homicides relating to firearms in the United States over the same 6-year period. 120,000. And here you have the ATF, DOJ, and a brief of the Supreme Court literally talking about this crisis, this public safety crisis and existential danger involving 692 homicides. Well, if you take 692 homicides, which I did back of the napkin stuff, and you divide that by 120,000 homicides to see how many gun-related homicides over that 6-year period arose from these so-called ghost guns. Again, it's a number that is less than 1/2 of 1%. It is a negligible de minimis number. Now, every death that's by homicide is too many in my view, but the reality is you got gangbangers and criminals and felons and terrorists out there, so you're going to have some death. It's just part of society. Ever since Cain killed Abel, you're going to have evil violence. It's just part of the human experience. All right, folks, so this is just a few of the absurd arguments, the highlights. Having skimmed through the Department of Justice brief, there's a lot more arguments against what DOJ is. I don't see a way for DOJ to win this case. I think they're going to get spanked badly by the Supreme Court. But I just wanted to illustrate some of the absurd positions and arguments that they are advancing to take away our right to keep and bear arms. And even though this is an ATF authority case, the reality is this speaks to our right to keep and bear arms because they want to make sure that even if you acquire gun parts as defined by anything that could conceivably be converted with milling or manufacturing or adding to the parts or manipulation, anything that in your hands that could be manipulated in some way to become a frame or a receiver of a firearm, and thus by definition under the Gun Control Act, a firearm, they want that to be regulated. They want that to be serialized. They want you to get a license, and they want you to go through a background check because this is all about the goal of the anti-gun movement and the DOJ under Biden and Harris to somehow have a national gun registry and a gun owner registry. I don't think they're going to get there, but this is what this is all about. And I think it's not going to work with the Supreme Court because these arguments that I've just pointed out here, the absurdity of them, I can assure you that the Supreme Court justices are smart enough to pick up on the points that I just made. So we'll see if any of the justices talk about these points at the oral argument, but I can assure you that they are sharp and the law clerks are smart and they're going to pick up on this. So anyway, hope you learned a little bit something here today at the Four Boxes Diner. Make sure you follow me on X. We have almost 18,000 followers over there on X, I believe, at Four Boxes Diner. Don't forget to like this video and share it widely. Make sure you subscribe. We're trying to build our subscriber base and look forward to seeing you all out there in San Diego at the Gun Rights Policy Conference sponsored by the Second Amendment Foundation at the end of September. And again, look forward to seeing you here yet again, I hope, at the Four Boxes Diner.
Orders up. Table 2A.